Welcome to Oil and Gas Law with Energy Law Prof. Today we'll talk about making royalty payments. So as a reminder, here's a typical Texas oil royalty clause. It would say the royalties to be paid by the lessee, i.e. the oil and gas company, are as follows. On oil, 1/8 of that produced and saved from said land, the same to be delivered at the wells or to the credit of the lessor into the pipeline to which the wells may be connected. Or it might say, or in the absence of a pipeline connection, to the transporter receiving lessee's oil and at the same price received by the lessee. So in other words, money in that case and not oil. So that's a typical Texas oil royalty clause. Let's think about what are some of the problems that happen if those royalties are not paid on time. So you might wonder, okay, if there's a failure to pay that royalty on time, is that like the failure to pay a delay rental under an unless clause, or a failure to pay a shut-in royalty on time in a lease that makes continuance of the lease dependent on timely shut-in royalties? The answer is generally no. So generally, unless the lease says so, a failure to make a royalty payment on time isn't necessarily going to cancel a lease. Okay, so that doesn't. So if you fail to make that royalty payment on time, you're, as an oil and gas company, you're liable for that. You certainly can be sued for that. We'll see that often you're going to have to pay interest as well. But it's unless the lease says that failure to make the payment on time cancels the lease, the courts are often not going to cancel the lease. Now, what kind of remedies might you be able to get as a landowner if the oil and gas company doesn't pay on time? Well, here's a couple things. One is, effectively, if what you were supposed to receive was the oil in kind, as we saw as a sort of default under that oil royalty clause, that's effectively conversion, right? So if you remember from criminal law, conversion, basically the oil and gas company just stole the oil that it was supposed to leave for you at the well. And so you're going to have the same kind of remedies that you would have in conversion, where somebody basically just simply takes your property. Now, if what you were due instead was money, then what you're going to be able to get from the oil and gas company is damages. Different states have different provisions on whether leases may be able to be canceled if royalty payments are very far late, etc. You can see that there's different statutes in Louisiana and North Dakota on this. And of course, there can be lease provisions that say, and we'll see these later in class, if you make a late royalty payment, I can cancel the lease. Now, it's important to understand that if you are owed money by the oil and gas company, that can leave you in a difficult situation because you're usually going to be an unsecured creditor, which means that if the oil and gas company goes bankrupt, you may not be able to recover those damages. Now, there are different statutes from state to state on royalty payments. Some allow you to make a lien on the oil and gas company and its production. Others prescribe a certain specific statutory interest, and of course there can be interest even if you're suing just under general common law provisions. And so generally the oil and gas company, if it fails to pay that royalty, is going to be liable to you for the money that is owed and also for interest for the late payment.